My name is James Trost, and this is A2 Insight. Today, we're very honored to have as our guest the Chief Justice of the Michigan Supreme Court, Bridget McCormack. Justice McCormack, welcome to A2 Insight.
Thank you for having me. I'm excited to be here.
Well, we're glad to have you here. I'd like to start out with, as we do with all of our guests, give us a little bit more information about your background, where you grew up, early influences, and let's go into your early professional career.
Sure. I grew up in New Jersey and had two siblings who now both live in Los Angeles. And we have no lawyers in our family. My dad was a small business owner, my mom was a social worker. But I had a godmother who was a lawyer, and she didn't have any kids of her own. She was actually a legal aid lawyer in New York City. And so she spent an awful lot of time with me. I think I had the best godmother in the world because she didn't have any of her own kids. And I went to work with her a lot. And she had an important influence on me on deciding to go to law school. I went to school on the East Coast. I went to a small college in Connecticut and NYU Law School, then practiced as a public defender in New York City before becoming a legal academic for the next sort of decade and a half.
Mm-hmm. And when you say legal academic, that means you went into the academic world. And where did you go into your academic career?
Well, my first academic job was at Yale Law School, actually. I was a research fellow at Yale Law School for 2 years, and then went on the national job market and landed a job at the University of Michigan, go Blue, and was a very happy law professor at the University of Michigan for a long time. I shouldn't say was, because I still teach there as an adjunct till today. Until today?
Yeah. All right. Well, thank you for your service to the University of Michigan. As a law professor at the University of Michigan, you do other activities in addition to teaching students. What subjects were you teaching when you were in school?
So I taught, some traditional topics I taught were criminal law, legal ethics, but I primarily taught clinical classes. And in law school, like in medical school, law students now more and more frequently get class credit for representing clients, people who could not otherwise afford lawyers, under the supervision of faculty. And it turns out to be an incredible learning experience for all sorts of reasons. So I taught a number of clinical classes and was in fact the associate dean of the clinical program. And among those clinics were a pediatric health advocacy clinic, the Michigan Innocence Clinic, a domestic violence clinic. I taught a number of different clinical programs.
Now that's very interesting, because that does lead to something specifically that you were doing while you were teaching at the U of M, and that is this whole Michigan Innocent Project. In a sense, project. Could you tell us a little bit more about the impetus of that, what its goals are, what its motivations, and what are its outcomes that when you got in, how you got involved in this specifically?
Yeah, I will. I did a number of cases as a clinical professor here in Michigan before we founded the Innocence Clinic, where the clients we were representing had been wrongfully convicted. And it takes a special kind of legal work to undo a wrongful conviction. And you and probably your viewers are familiar with the innocence projects around the country who have, over the last 20, 25 years, secured a number of exonerations, many of them because of DNA. The advent of DNA evidence has been able to prove beyond a reasonable doubt that the wrong person has been convicted in lots of cases. But as you might imagine, it's not only cases where there is some blood or other serological evidence to test that things go wrong. Things go wrong in cases where there is no biological evidence from which we can have a DNA test done. And we thought the U of M Law School would be a great place to focus on those hard cases. And that's what we did. It was actually, we founded a non-DNA innocence clinic. There's already a DNA-based innocence clinic at Cooley Law School, so somebody's already working on that. So we decided we're going to focus on these other cases where it's the rate of wrongful conviction is not going to be lower, but they're going to be harder. So let's put some smart students to work on that.
Mm-hmm. Well, and that's an interesting question, Era. Just an observation. We can see DNA is pretty obvious because of just the technology. But what other, through the efforts of the research that's done with your students and what you've done, what is, when someone's wrongfully convicted, what are some of the reasons why someone would be wrongfully convicted?
Yeah, we know a lot about that. We know both a lot about the rate of wrongful conviction and the reasons for it, because there's now this database. There's now this enormous group of cases from which scholars have been able to, study exactly those issues. So the kinds of things that go wrong that create a wrongful conviction are and this is in no particular order, although I'll save the biggest for last. Bad forensic science, which is an issue I have worked a lot on and care a lot about. False confessions. False confessions lead to wrongful convictions. Bad identifications. Identification testimony is incredibly powerful and also incredibly fragile. Testimony where somebody who is him or herself implicated points the finger at somebody else, that kind of testimony ends up occurring in a lot of wrongful convictions. And the final one, and probably the most significant one, is poor lawyering. If we had more robust, better lawyering at the trial level, we'd have fewer wrongful convictions. It's that simple.
Interesting. Well, glad to see that we're doing that, and that this project that's done through both Michigan State and Cooley also in Michigan are involved in that. Now, while you're at the University of Michigan Law, somehow you then move on to another project. How did you get involved, or when did you decide to end up on the Michigan Supreme Court? How did that come about?
Yeah, I don't have a typical career path. So although historically, I will say that there was a relationship between the law faculty and the court. Justice Cooley, Chief Justice Cooley, who was one of the most important justices in our nation's history. Frankly, his scholarship is still incredibly important. He was a law professor at the University of Michigan Law School when he went to the court. Now, unlike him, he did both jobs full time for the next 20 or 25 years. I went to the court and kept teaching as an adjunct one class because for me, the full-time job on the court was enough. But I'll tell you, there was an open seat in 2012, and I practiced in the court with our clinical cases. I often filed leave applications in the court and appeared there. And I had good relationships with the justices on the court. And it was actually my husband who first said, "There's an open seat. Why don't you run for the court?" And I thought it was a crazy idea and dismissed it quickly. But over time, I kept thinking about it and thought I could actually do a good job and contribute. And so I kind of ran for maybe naive, old-fashioned reasons, thinking I could contribute in a positive way, and didn't exactly know what I was getting myself into with the whole statewide election part of it.
Mm-hmm. Well, we've had several politicians on this program, and the whole concept of running for office and what they like about running for office, what they don't like running for office, and particularly here locally we have various council members going door to door talking about the positions. And it seems to me you're running for a judicial and a judgeship or is a different animal at one level because you're not really.
Yep.
So what would you say you liked the most about running for office, and how would you say it would differ than a traditional political campaign in your experience when you did this, what you were not knowing what you were going to get into when you ran for this?
I mean, it's different from a traditional political campaign for one incredibly important reason. It's a nonpartisan office, and it's a nonpartisan office by constitutional design. I mean, our founding fathers decided that we needed a branch of government that was to be independent and was to be removed from partisan influences. And the reason for that is because we need our judges and our courts to make hard calls, unpopular decisions. A court that's doing its constitutional job is disappointing partisans on both sides all the time. So, which makes you not always popular. So it's weird to run for an office where you need to get the most votes. Sounds like a popularity contest. And it's hard because all you can really promise is this, your commitment to the rule of law. So someone would say, well, what can you promise me? And I would say, I'm going to work really hard. I'm going to read everything. I'm going to be faithful to the rule of law, and I might disappoint you. And that's not a great campaign promise. I might let you down. It's not really let you down, I hope. It's you might not like the answer.
Well, actually, I think some of our politicians would prefer they would have that option. Do that. But all right, well, you get on the Supreme Court here in the state of Michigan. And then let's move around, talk about popularity contest or whatever. Your colleagues have decided to have you become Chief Justice at this time for a term, I believe. I don't know how the system, 1 or 2 terms or however it works.
Yeah, it's 1 term, and then if they think I've done okay, they'll renew me.
And so I guess the question would be, you've been there since 2012. What would you say are the main differences between being an Associate Justice and now that you have the role of Chief Justice? What is the difference in the roles? I
mean, the big difference is the Supreme Court, in addition to our opinion deciding function. The function most people are familiar with. That's what they read about us in the papers. They read the Supreme Court decided this case or that case. But in addition to that, the Constitution directs us to be responsible for administering all the courts of the state. So that means we need to support and administer all of our trial courts throughout the state. And frankly, that's where most people experience the justice system, and frankly, sometimes, often, when things aren't going well for them. So our courtrooms, our trial courtrooms around the state are where the important business of the branch is getting done. And that administrative part of the job is enormous. I mean, we have an enormous administrative operation at the Hall of Justice. I think there are over 180 people who work in the Supreme Court Administrative Office, and they, now report to me. Frankly, I have great colleagues on the court, and many of them are taking the lead on many of the sort of administrative areas that we are busy in, and I'm grateful for that, because it is a job for more than one person. And so while I'm involved in a lot more of it than I might have been as an associate justice, I feel like I am grateful to have good colleagues who participate in it as well.
Well, that's good that you're doing that. And of course, as that role, you also have a rather ambitious project in terms of reformations and reforms you want to have in the system itself. We'll go back, we'll get to that at the beginning, but I think for most of us that are from the outside looking into the judicial system, one of the concerns we have is the whole concept of pretrial practices, length of time that it takes to, you hear about a case that's going 2 or 3 years later, and it just seems to still be in motion and everything else. Do you have any specific ideas about how you could possibly reform, maybe a little bit more, this whole concept of pre-trial practices and why you feel that might be necessary?
Yeah, I'm actually very happy to talk about this topic. This week, the governor announced that she signed an executive order. In fact, we all announced it together, setting up a task force on pretrial and jail detention that is the result of an agreement between myself as the Chief Justice, the governor, the Speaker of the House, who's a Republican, the Senate Majority Leader, who is also a Republican, the Michigan Association of Counties, and the Michigan Sheriff's Association. We all together agreed to work with the Pew Charitable Trust, who has, we are grateful, given us $1 million and a number of full-time staff people to help us collect the data from our jails around the state so we can, for the first time, actually understand who's in jail and why. We know anecdotally, and we know from certain of our populations that it's at least 50%, sometimes higher, in our county jails where the folks that are there have not been convicted of anything. They're just people who can't afford to pay their bail while they are awaiting their trial. And that's can be harmful, because that means they're not paying their child support, they're not going to work, often they're losing their job, they're not taking care of their kids. And so it's very costly to counties, and not to mention that every night in jail is anywhere from $75 to $150 depending on the county. And so counties are paying big prices for this. So we have this bipartisan every branch of government and state and local government all announcing that we are going to work together to figure this out and come up with some good policies that will both keep communities safe and keep communities strong. And we're really excited about it.
Well, that's encouraging. Good timing on that whole concept, because it really, I think that is a concern that people are living in jail and we're waiting, and these things tend to go on and can go on. One other thing I think people would be interested in knowing, I think it's just the whole structure of the judicial system, where we have our civil courts, we have district courts, but then we also have appellate courts, and then we also have the Supreme Court. So could you tell me how does a appellate court, in the area would be considered an appellate, the Supreme Court is an appellate court
in that
sense, and so how does an appellate court practice differ from the lower court proceedings, and how do you and your colleagues decide which cases to take?
Yeah, good questions. As I said before, most people experience their courts in the trial courts. Those are the district and the circuit courts in Michigan, also probate courts. A couple places we have municipal courts, but not too many of those. That's where most people experience the court system. If you don't like the result that you got in the trial court, you can ask the Court of Appeals, which is not the Supreme Court, it's an intermediate appellate court, to review that decision. Now, the Court of Appeals only gets to change the result if there was a legal error. A legal error means not that they thought they would have voted the other way if they were the jury, it's that something went wrong with the law. If you don't like the result you got at the Court of Appeals, you have the option of filing a leave application with the Supreme Court, and that's our court. That means that you can ask us to take your case. It doesn't mean we will. And in fact, a lot of the work we do, and most of the work we do, is reviewing all of those applications and deciding which of those the Supreme Court really should hear. And we have rules for which cases we should hear, and they really, they wouldn't surprise you. There are cases that have statewide importance, cases of first impression, cases where there have been conflicting decisions in the intermediate appellate court, and we need to bring some clarity and some predictability to the law. At the end of the day, your courts should be able to provide a rule of law that everybody understands and can follow, and they can organize their personal and family business around it. So that's our job, not to fix anything the Court of Appeals got wrong necessarily, but to make sure that the fabric of the law is smooth.
Well, again, it is similar to the United States Supreme Court, and I'm sure you get quite a few appeals. I guess the question would be, out of how many appellate cases do you and your colleagues go through in a year, and how many cases do you hear?
We get about 2,000 applications a year, and of those 2,000, we speak every Wednesday about some subset of those that we think are close, and we should talk about whether this is one we should take or we should take some action in. We don't. There are a few different things we can do with a case. Sometimes we get an application and we say, yep, we're going to have to hear this case. Let's set it for oral argument, get full briefing, have the parties in, have argument. Sometimes we think, it seems to us that the Court of Appeals didn't actually, decide one of the questions that is important here. We can remand it to have the Court of Appeals decide something that it took a pass on. We can remand a case to the trial court if, in fact, there was a hearing requested that should have been granted and was never. So we take some action in, 250 or 300 of those 2,000 applications. We discuss all of them, and then we take some action in some smaller number of them. Of the ones that go all the way to argument, and we actually hear them and then decide them after argument, that's a much smaller number. That's between 60 and 70 a term.
All right. So it's a long time before anything gets to your review.
It's a lot of work to narrow it down.
I would think so.
Yeah.
Yesterday on our show, we had Mary King, who works in an organization trying to reform some of the criminal procedures that we have in our system. And she gave an interesting statistic that in the early 80s, there were 7,000 people incarcerated in the state of Michigan. And then up until now, we're up to 55,000 people. So we've seen an incredible increase in just the number of incarcerated people. And it just interests me, from your perspective, and you've been in the legal system, you've been in the judicial system, where did that come from? Where was this motivation behind this increase, such an incredible increase in the building of prisons and all over the state? What's your take on why this was so exponential?
I mean, there are a lot of people who know a lot more about this than I do, but I'm interested in it, so I do read about it. In fact, there are a lot of interesting books about it out right now. But there was, as you might remember, in the 90s, a lot of federal legislation that was really aimed at tough on crime. It increased mandatory sentences, and obviously federal legislation only applies to federal prosecutions, and federal prisons are a very small part of our prison population. But all of that legislation also had with it sort of carrots and sticks for the state criminal justice systems and prosecution offices that got funding if they prosecuted certain types of cases or if they increased penalties. And so there was really in response to some, what was it at the time, higher crime rates, especially around crack cocaine, the societal response was longer prison sentences was the answer. And we've seen the results of that. And we're now, I think, kind of coming to terms with that and trying to decide, did all that make sense?
All right, and time will tell on that. We'll see how that evolves. Going at the same time with that subject, you mentioned that, particularly with the Innocent Project, at the top of the list that you mentioned was a lack of adequate legal counsel. And we hear the horror stories of people having, one a criminal defense court-appointed attorney having 200-300 cases, and you can see them going in the courtroom with this stack of folders that's this high, and clients are in and out, and they just don't have time for one thing, and they're overworked. I guess that if that's the main problem, how do we as a state or as a system, not everybody is doing criminal law, not everybody's going to do pro bono work when they're getting into other fields. So what do you think would be a real effective way to increase or at least provide better legal counsel for those accused in our system today?
It's actually a problem that Michigan is working on and making significant progress on. The Michigan Indigent Defense Commission, which was founded, I don't know, 6 or 7 years ago. It was, in fact, a collaboration between the Michigan Supreme Court and the former governor's office, Governor Snyder's office. And it first was established protocols for how counties, and sometimes counties banding together, could provide counsel, meaningful counsel, for indigent criminal defendants. And interestingly, the legislature funded it a couple of years ago. So now it's not just a set of really good ideas. It's a set of really good ideas with some funding that comes with it. And frankly, I think everywhere around the state, I think they're still working a little bit on the city of Detroit and Wayne County, but they're getting there. They're making progress. Has made significant progress toward a system that will provide, meaningful representation for indigent people accused of crime. But it takes an investment at the front end. What I always like to say is, if you have good lawyers at the front end of these issues, you can probably find better solutions rather than waiting, 5 or 10. Most of the people who go into our jails and into our prisons are coming back out into our communities. So figuring out how we want to respond to them at the front end is really important. We do a lot in the courts now, the trial courts, with mental health, sobriety, and other problems, issues that actually are really the underlying reason why somebody ends up in criminal court. If we address those underlying issues, we're going to have better success rates, on the back end.
Well, so many of these things tend to be really funding related. I mean, as I mentioned, Ann Arbor passed a resolution in Washington County to try to shift the focus. Sheriff Clayton was in on this too, to try to be more treatment oriented for folks. When Mary King says that maybe 30 to 50% of our population are either drug related offenses or some crime committed while under the influence of a drug. So this concept of treatment seems to me a much more efficient than punishment, but we'll see where that evolves. Now, the other thing is, you are now the Chief Justice of the Michigan Supreme Court, and I did go through your blog and your website to see, so your colleagues have elected you, and you did mention on there that you have 4 principles that you would like to provide in leadership to the judiciary. And I hope you can go over just how these would be defined by you.
Yep.
And the 4 areas were independence, accessibility, engagement, and efficiency.
Yep.
So how will you gauge the success in these 4 areas as our Chief Justice?
That's a great question. So each of those, let me say, are important to me, but important to my colleagues as well, and also important to the public. We actually know a lot about what the public wants from their state courts, because the National Center for State Courts extensively surveys the public every year. But the thing they say over and over again is they want independent courts. So they want exactly what we talked about sort of at the top of this interview, what the Founding Fathers envisioned. They want a court that's going to make independent decisions. And the best way to judge that is if whoever's mad at me on Monday is really happy with me on Friday, and that the other guy who was really happy with me on Monday is mad at me on Friday. And so far, I think we're nailing that one. I can't tell you how often I see people who are real mad about one decision and the next week real happy, and I think, well, that's the way it goes. My colleague David Viviano told me at the start of my job, if you're not able to come to terms with the fact that you have to be willing to lose friends and lose elections in this job, you're not cut out for it. And I think he's right. That's independence. By accessibility, I mean we have to make sure our courthouse doors are open to everyone. It's not okay that people can afford more justice than other people. So we have to be able to figure out ways to make sure that people who can't afford lawyers can get their voices heard in court. And there are lots of ways we're working on that. We have a fantastic self-represented litigant website, mylegalhelp.org. It's scalable to infinity, but we're working on a bunch of other ideas for that as well, and we'll be announcing a major initiative with Access to Justice before long. So stay tuned for that. Accessibility means we need to make sure that our judges, and it's really the trial judges, again, they're the ones doing the hard work, frankly, they really are engaged with the public about what's going on and what matters to them, right? So if, we know in Washtenaw County, like Sheriff Clayton is, Sheriff Clayton knows that mental health and substance abuse are playing an enormous, oversized role in our criminal justice system. Our judges need to know that too. Sheriff Clayton knows that because he's out in the community talking to people. And because of that, he can be better responsive to what the community needs. And judges have to do that too. I feel like ours do a great job with that, but I want to emphasize that. And then what I mean by efficiency is not, saving money at the expense of any of those other values. I mean, we need our courts to be places where people can get their business done, which is usually difficult business. It's not happy things that you go to court for, in a way that doesn't take too much time or too much money. I mean, it's just, I think the court of our future is going to have to make everything simpler and easier and navigable by regular people, often without lawyers. That's just the way it's going to need to be. So we are really expanding online dispute resolution in lots of cases where people wouldn't normally be able to hire, or wouldn't normally hire lawyers, like landlord-tenant cases and small claims cases, so they can actually resolve their disputes in the evenings or on weekends on their smartphones. And anyway, that's kind of what I have in mind.
Mm-hmm. Well, that is certainly would be, I don't know how the lawyers would appreciate having not to have it, but that's a different...
I have to talk to them all the time, and I tell them why I think it's important.
Right. Well, so, I think that goes back to your point of not being able to please everybody all the time.
That's right.
For that. And it does, because it is interesting when I deal with the questions of the judicial system with various guests talking about it. Always is that money and funding is always an issue, and efficiency and saving money is always at the top of the list. How do we utilize the dollars in the greatest way? But then the other side of this, and I really want to get your sense of this because it's really a shocking statistic that I ran across, is the amount of courts, particularly local district courts and other, that their funding comes from the amount that they get from the various folks that come through their courts.
Yeah, it's an enormous problem. Yeah.
And I guess, I've seen some courts where it just seems to me I'm not going to generalize, but extracting a fine or a penalty, isn't there, just by definition, a conflict of interest for a court that relies on its own costs and coming and extracting fines from people? And do you see this as a problem?
So we currently have a case pending before our court that deals with this question, so I'm actually not going to speak too much to it substantively. I will say that the legislature actually set up a trial court funding commission to address exactly the question you're asking, and it produced its report last week, I think 5 months early. The commission did fantastic work, and they have a set of recommendations aimed at addressing exactly this issue. And I'm heartened that the legislature is interested in it, and that the commission worked long and hard to produce a report in a quick amount of time.
Mm-hmm. All right. Well, that's as best as you can get, given the fact that it may be something that appears before the court. Obviously, we don't want to have any presuppositions. Well, we're getting near the end of our program, and I just want to ask you one more question. You've had an interesting career so far. You've been active in a variety of different things here. I guess I'm wondering, now that you're on the court, and you're in a political office regardless, but you still have to run, but you're nonpartisan and has some advantages over running for political office when you can offend everybody or nobody at the same time. When you think about now that you're on the court, is this where do you see yourself, and whether this can be either personally, professionally, and let's say 5 years from now that you've had this, is this a lifelong commitment? And just remember, where do you think that your own career, because you've had some interesting shifts along the way, where would you like to see yourself in 5 years, Justice McCormack?
In 5 years, I hope I'm still serving the people of Michigan on the Michigan Supreme Court. I have a lot more I feel like I can contribute. I'm still young enough. I'm healthy, and I feel like while I'm here, I want to do as much as I can. And I have, as you might be able to tell, I have a list of things I really want to do and get done, and I think they're important. And 5 years is not quite enough time to finish it all. So I hope I'll be right here. Unless the voters want something different, and that's up to them.
Chief Justice Bridget McCormack is the Chief Justice of the Michigan Supreme Court. I want to thank you very much. We've been very honored to have you here as a guest today on A2 Insight.
Thank you for having me. I appreciate it.
Mm-hmm. And until next time, I'm James Trost for A2 Insight. you.